Chapter 24 General Provision as to Inquiry and Trial Section 300 to 327 E is tried for voluntary causing grievous hurt and convicted. The victim subsequently die. The state want to try A for the offence of culpable homicide amounting to murder under IPC. Which one of the following is correct legal preposition? A can be tried for second time for culpable homicide amounting to murder. Which one of the following section of CRPC prohibit against the trial of a person who has been tried by the court of competent jurisdiction for offence and convicted or acquitted of such offence? Section 301. Which section is based on the maxim nemo det bis vixri pro idem causa? A man shall not be twice vexed for the same cause. Section 300. Which one of the following section of CRPC provided that a person once convicted or acquitted shall not be tried again for the same offence? Section 300 clause 1. Which section of CRPC provide protection against double jeopardy or actus foci convict? Section 300. Which one of the following section of CRPC provide that person once convicted or acquitted cannot be tried again for the same offence? Section 300. Which one of the following section is based on the doctrine actus acquit or atrophosis convict? Section 300. Which one of the following person is entitled under section 302 of CRPC to conduct the prosecution of the case without the permission of the magistrate? Public prosecutor, government advocate, assistant public prosecutor. When the accused does not have sufficient means to engage pleader, the session court may assign the pleader for defense at expense of the state. It is ensured by the section. Which section of the CRPC? Section 304. Section 304 deal with legal aid to the accused at state expenses. In which one of the following section of CRPC provision for legal aid is made? Section 304. If the accused before session court cannot engage a pleader, the court shall engage a pleader for him at state expenses. Where the trial before the court of session, the court is not represented a pleader, and where it appeared that court that the accused has not sufficient means to engage the pleader, the court shall assign a pleader for his defense at the expense of the state of the Code of Criminal Procedure 1973, Section 304. Where it appears that court that accused do not have sufficient means to engage a pleader, court has assigned the pleader for his defense at expenses of state. This provision is in Section 304. Section 304 of Code of Criminal Procedure provides for, in certain cases, making available a pleader to accused at the expenses of the state. Court may assign a pleader to accused in a trial when it appears to court that accused do not have sufficient means to engage one. Consider the following statement regarding legal aid to accused at state expenses. Legal aid is right of accused available in the trial before session court only. Provision of section 304 of CRPC applies only when in the trial before the accused is not represented by the pleader and it is appeared that he does not have sufficient means to engage a pleader, court of session. Legal aid to the accused of the state expenses is is a provisions of law under dash of CRPC section 304. Who among the following is not empowered to tender a pardon accomplice under section 306 of CRPC? Magistrate of second class. Pardon may be tendered to accomplice under section 306 of CRPC. He undertake to make full and true disclosure of the fact relating to the offence. Who among the following can tender a pardon of accomplice under section 306 of CRPC? Chief Judicial Magistrate, Metropolitan Magistrate, Magistrate of first class. When may accomplice be tendered pardon under section 306 of CRPC? At the stage of inquiry or investigation or trial. Who cannot tender pardon accomplice under section 306 of CRPC? Executive Magistrate. Provision as contained in section 306 of CRPC is related to pardon and accomplice apply of offence punishable imprisonment which may extend to 7 years or more. An offence who has accepted a tender of pardon may under section 306 and 307 has either willfully conceal anything essential or by giving false evidence not complied with the condition of which the tender was made. Who will satisfy the fact? Public prosecutor. When may an accomplice to tender pardon under section 306 of CRPC at any stage of these? When an accused person is pardoned against section 306 of CRPC, he became witness for the prosecution. A judicial magistrate first class may deny a pardon to person at any stage of the inquiry and trial only. Under which section of law the court has provided a direct tender of pardon to the accused before pronouncement of judgment? Section 307. Under section 308 of CRPC, an accomplice who does not comply with the condition of pardon may be prosecuted and tried separately for offence of giving false evidence but with the sanction of the High Court. Under section 308 of CRPC, an accomplice who does not comply with the condition of pardon may be prosecuted and tried separately for the offence giving false evidence but with the sanction of the High Court. Can a magistrate inspect any place of commission of offence during the trial? Yes, magistrate can inspect for a proper appreciation of evidence under section 3010 of CRPC. Under section 311 CRPC can be exercised by the court of to recall any witness already examined, to summon any witness who has been cited as a witness but not prosecuted or examined before the evidence is disclosed, to summon any witness who has not been cited as a witness. In terms of the provision of Code of Criminal Procedure, the power to recall any witness can be exercised even after the evidence of both sides is closed. Which one of the following statement regarding section 311 of CRPC is correct? All of the above statement. In confession, it confer the court with power to summon material witness, examine person present. It give a discretion to the court to examine the witness at any stage. It compels the court to examine a witness if his evidence appear to be essential. Under which section of the Code of Criminal Procedure at any stage the trial may recall or re-examine any person already examined? Section 311. Which statement is wrong? All of this statement is wrong. Section 311 of the 11A of CRPC empower the magistrate of first class to order person to give a specimen of signature. Power to recall a witness under section 311 can be exercised even after the evidence of the both sides is closed. A magistrate under section 311A of CRPC can order any person to give a specimen signature, to give a specimen handwriting. Under section 311 of CRPC, the witness can be called only the motion of prosecution, only the motion of defense, only its own motion by court. The statement of accused is recorded to enable him to explain the circumstances appearing in the evidence against him. Under section 313 of CRPC 1973, no oath shall be administered to the accused when he is examined. When examined under section 313 of CRPC, a circumstances incriminating the accused is not put to accused for explanation. The said circumstances cannot be used against the accused because law mandates that it cannot be taken into consideration. A court can put a question to the accused to explain any circumstances appearing in the evidence against him at any stage. Under section 313 of code, the purpose of examination of accused is to enabling the accused personally to explain any circumstances appearing in the evidence against him. Under section 313 of CRPC, the statement of the accused has been taken by the court not on oath. Which one of the following statement is wrong? Oath may be administered to accused before he can examine under section 313 of CRPC. During trial, statement of accused person are recorded by the court under CRPC under section 313. Which one of the following statement is wrong? Oath may be administered to any accused before her examination under section 313. For the purpose of section 313 of CRPC is to enable the accused personally explain the circumstances appearing against him in evidence. Accused statement under section 313 of CRPC is recorded on oath. Above nay statement false. Under section 313 of the CRPC, the statement of accused has been recorded without oath. Under which section of the CRPC accused can himself competent witness for the defense? 315. Whether an accused may be competent witness for his own defense if he apply in writing as his own request. Under which section of CRPC accused can himself be a competent witness? 315. Section 315 of CRPC related to the accused person as a competent witness. With regard to this, which one of the following among the following statement is not correct? An accused can compel to adduce evidence by court of law without any application in writing with him. Under section 315 of CRPC, an accused can be called as witness only his request is in writing. The accused has been called examine himself on request in writing. has been liberty not to give evidence without giving rise to the presumption of law. The accused person make competent witness of his own defense under CRPC in section 315. Under CRPC 1973, whether the accused may be competent witness of his defense on his own request in writing, in which one of the following section declare that accused person shall be competent witness. 315. In the case of the accused facing inquiry or trial through had not unsound mind but not capable of understanding the proceeding, the court may proceed with inquiry or trial, and in case the same result in conviction, forward the process to High Court along with the report, on which High Court shall pass such order as deem fit. Under section 319, a person may added as additional accused on the basis of evidence adduced in the case. Power under section 319 of CRPC is exercised by magistrate of the Court of Session both only after recording the evidence during inquiry and trial. For summon of accused under section 319 CRPC, both the statements are relevant. A statement under section 161 of CRPC is relevant. A statement on oath in the trial is relevant. The composition of an offence under section 320 of CRPC shall be effected of acquittal, where the person who would otherwise be competent to compound an offence under section 320 of CRPC is dead, then legal representative of such person can compound the offence with the consent of the court. The offence of IPC under than section 320 of CRPC are not compoundable. Compounding of an offence under provision of CRPC resulted in criminal cases acquittal of accused. Classification of compoundable and non-compoundable offence has been provided under CRPC in section 320. Offence committed under which section of IPC has not compoundable under section 320 of CRPC, section 253. Whether an offence is compoundable or not is provided under which provision of CRPC? None of the above. Offence other than those mentioned in section 320 of CRPC are not compoundable. An offence of voluntary causing grievous loss by dangerous weapon or means as provided under section 326 of IPC is not compoundable. What is the effect of compounding an offence under section 320 of CRPC? Acquittal. Compounding an offence under section 320 of CRPC result in acquittal of accused under all circumstances. Compounding an offence under the provision of CRPC when charge was framed result in acquittal of accused. Offence in which a compromise can be arrived at between the parties are compoundable offence. Which offence is not compoundable? 324. When a person competent to compound an offence under section 320 CRPC is dead, then his legal representative of such person can compound the offence with the consent of the court. Compounding the offence under the provision of CRPC result in acquittal of the accused. If the person who has competent to compounding offence is dead, compounding can be done by the legal representative of deceased with the permission of the court. When the person is competent to compound the offence of CRPC, Under section 320 of CRPC, the person in the possession of property is trespassed upon. Offences not covered under section 320 of CRPC are not compoundable. In a situation where the person competent to compound an offence is dead, the compounding can be done as a legal representative of deceased with due permission of the court. Which one of the following offence may not be compounded by person mentioned in the third column of table given under section 121 of the CRPC? Bigamy. Offense other than those mentioned in 320 of CRPC is not compoundable. Classification of compoundable and non-compoundable case has been provided under section 320 of CRPC. A faced trial for cheating of Z by dishonestly inducing him to lend money by knowing placing fake diamond. Z dies during trial and was survived by his son. X move an application in a trial court compounding the offence. Which one of the following correct is a correct legal proposition? X can compound the offence with the consent of court. When a person who otherwise be competent to compound the offence under section 320 of CRPC is dead, then legal representative of such person is defined as in the CRPC can compound the offence with the consent of the court. Which one of the following offence is cognizable, non-bailable, non-compoundable? Attempt to murder is punishable under section 307. A public servant having a charge of translation of document make an incorrect translation of the document with intent to causing injury to B. The offence committed by A is not compoundable. Who can withdraw the case from prosecution under section 321? Public prosecutor in charge with the permission of court. When a person would otherwise be competent to compound the offence under CRPC is dead, then offence can be compounded by legal representative of deceased with the consent of the court. At the time before the judgment, the pronouncement, the prosecution of any person may be drawn with the consent of court by public prosecutor or assistant public prosecutor in charge of the case. Offense other than those mentioned under section 320 of CRPC are not compoundable. Offenses which is compoundable is provided under section 320 of CRPC. In which one of the following section a list of compoundable offenses is given? Section 320. Which one of the following offenses is compoundable? 498, 403, 40298. Under CRPC, the classification of compoundable and non-compoundable offense is given under section 320. Compounding an offense will result in acquittal. Where the offense has been compounded under section 320 of CRPC, such composition of offense shall take effect by acquittal of accused under all circumstances. Where a person who is competent to compound is dead, compounding can be done by the legal representative of the deceased with the permission of court. Who can withdraw a case from prosecution under section 221? Public prosecutor in charge of the case with the permission of court. Which section of CRPC provides the public prosecutor in charge may with the consent of court at any time before the judgment is pronounced withdraw the prosecution of any person in respect of offense for which he is tried? Section 321. Which section of CRPC authorized public prosecutor to withdraw prosecution? 321. any public prosecutor or assistant public prosecutor in charge of case before judgment is pronounced withdraw the prosecution of any person. With these he has taken consent of court, state government, central government. Who among the following may withdraw prosecution of any case at any time before the judgment is pronounced? The public prosecutor. Prosecution of the case involving misappropriation of property belonging to central government can be withdrawn by the public prosecutor appointed by the state government on the permission granted by the central government. The court, after the commencement of public prosecutor evidence, allow assistant public prosecutor to withdraw the prosecution. The accused can be released on acquittal. Appropriate government withdraw from the prosecution by prosecutor under section 321 of CRPC can be made only after decision has been given made in good faith in the interest of public policy by the prosecutor independently or oral consideration of the material before him to this effect. Which provision of CRPC permits the public prosecutor in charge of case to withdraw from prosecution? Section 321. At any time before the judgment is pronounced, prosecution of any person may be withdrawn with the consent of court by assistant public prosecutor or concerned APP. The public prosecutor or assistant public prosecutor in charge of case may be consent the court at the time before the judgment is pronounced withdraw from the prosecution any person either generally or in respect of any one or more the offense which tried. This is related with which one of the following section of CRPC? 321. In the CRPC, the provision of withdrawal from prosecution is contained in section 321. The withdrawal from the prosecution of public prosecutor is given a charge is required to be framed before the charge has been framed shall have effect of discharge. At the trial it appears the magistrate that case is about to be tried by court of session, in which case the court of session has committed a case. 323. Besides section 209 of CRPC, other section also provided for committal of case of session under section 323. Whenever a magistrate is in opinion after hearing the evidence for prosecution and accused that the accused is guilty and that ought to receive to serve the punishment, then such magistrate is empowered to inflict. The magistrate may forward the case to Chief Judicial Magistrate. A, B, C are charged for robbery and other trial convicted first class magistrate. After whether for same fact they can be charged and tried for dacoits. Yes. In the case where an injury trial other proceeding have conducted in wrong place, the injury trial and other proceeding cannot be set aside as a void unless the occasion in the failure of justice. A matter before the court which is not an evidence in the case testimony of the expert. Under Criminal Procedure Code, when the inquiry or trial related to offence under section 376 to 376D of IPC, within which period the inquiry or trial shall be possibly completed from the date of filing of the charge sheet, 2 months. The offence punishable under which one of the following provision is bailable? Section 323.